Okay, welcome everybody to join our GoElite webinar. Today, we're going to talk about solutions for H1B layoff, as well as expiration with a full guide on change of status. And today, we want to welcome our guest, Joyce Rowe. This is her first time working with us on the webinar. She is a immigration attorney. She also have her JD and is a California State Bar attorney. And in today's meeting, we're gonna talk about timelines and solutions if you do encounter this H1B layoff, and how will H1B termination gonna affect your green card application and certain things like that, and what is a change your status application and what are the popular options. And then we're also gonna leave half of our webinar sessions with a live Q&A. And if you, after this webinar, if you have any follow-up questions, please feel free to scan the QR code. The code will be on our presentations, so you can talk to our consultant. Before we go in, I do want to introduce everybody with a little bit of detail about our company. We are headquartered in Los Angeles. We are a professional consulting agency dedicated to help international students. So our main services would be day one CPT university applications, F1 reinstatement or emergency transfer, as well as change of status applications, for example, changing from H1B, H4 to F1. And our mission is to make your American dreams come true. We are a AIRC certified agency. We are the sixth AIRC agencies in the whole American, which is one of the most respectable, organizations in the education space. And we are on Google reviews, so feel free to check us out on Google reviews. We currently have more than 270 Google reviews, 5 stars. And this is our contact information and our social media. We do have social medias on LinkedIn, YouTube, WhatsApp, and Facebook. So feel free to check us out on all the social medias. And without further ado, I want to welcome Joyce to let her introduce herself. Hi, Joyce.
Hello. Hello, everyone. My name is Joyce Rowe. I'm happy to meet you guys online today. As I'm an attorney admitted to California State Bar, currently as a founder and a managing attorney of Rohan Law Office, I practice law in Buena Park and Orange County, California, and I'm specialized in immigration law. I'm handling change of status cases at GoElite and provide legal consultation for current and potential client. And in my law office, I manage non-immigrant visa and status cases and family-based green card process, employment-based green card process, and national interest waiver, AB5, and naturalization cases. In fact, I'm from South Korea and I'm used to be an international student for so long. I attended undergraduate program here and law school in the United States and became a permanent resident. So whenever handling immigration cases, especially for change of status and green card, I totally understand each client's situation and their desire.
Yeah, absolutely. Thanks for your introduction, Joyce. And I think as somebody who's been through the whole journey of being an F1 student, H1B's green card, and be through the whole thing, I think you will be able to provide us with the insights of what is like going into certain steps. So I'll let you sorry to stop you. I'll let you go on
No
with our
problem.
presentations.
Sure. So today I'm going to talk about change of status, specifically for 3 topics. First, I'll talk about what happened if H1B is terminated. And second, I'll talk about how H1B termination will affect your green card application. And third, as an option for after H1B layoff, I'll explain what the change of status is and what would be popular non-immigrant status. I'll give you a 30-minute presentation, and I'd like to have your question through a Q&A session after that.
Absolutely.
So currently, we all live in difficult times because of the downturn of the global economy. Everyone says that this is such an uncertain economic time, and many people were experiencing being laid off. Accordingly, H1B employees were also heavily laid off in 2022 and 2023. According to the Economic Policy Institute, the top 30 H1B employers hired 34,000 new H1B workers in 2022, whereas they laid off at least 85,000 workers in 2022 and early 2023. Annually, new H1B workers are kept at 85,000. Of course, many employers such as university, nonprofit research organizations, government research organizations are exempt from this annual cap. So approximately 130,000 temporary workers receive new H1B visa or status each fiscal year. Considering this number of new H1B workers, 130,000 annually, you may realize that laying off 85,000 H1B workers is quite a serious issue. Unfortunately, it is presumed that laying off across the United States will be continued and H1B workers shall be continuously impacted during this economic difficult time. So, next page, please. Yes. So being laid off means that your H1B employment relationship with your employer will be terminated. And here we need to understand what happens if H1B is terminated. Either voluntarily or involuntarily termination of H1B, an H1B holder will be given a grace period, which is 60 days. The grace period is allowed once one H1B visa or status is granted, meaning that you receive I-797 on approval notice of H1B, and then you'll be able to use the 60 days grace period. And this grace period begins to run once H1B employment is terminated. So, for example, if you, as being an H1B employee, were laid off and you spent your 60 days grace period as you are looking for a new employment, luckily you found one and you were able to file the petition for transferring your H1B. Then you receive your I-797 from your new employer upon the successful H1B transfer. That means that you will be given another 6 days of grace period because you got a second I-797 approval notice. So whenever you need to count your grace period, please remember that you will have it upon receiving I-797 and it begins to run upon your termination date of H1B employment. An H1B employer has a duty to notify USCIS regarding the termination of your employment. Sometimes H1B employers are not diligent to report it promptly. So if you need to carefully count your grace period, I recommend to speak with your employer about it. But to conservatively approach this issue, it is better to presume that when your employment termination happened, then your grace periods begin as well.
Okay, questions. So if, for example, if I got laid off on my H1Bs and then my employer have to inform USCIS, that's when the grace period start to count. For example, if I go on a unpaid leave, then in that case, I'm still on, on the company's roster. Is that correct?
Correct.
My grace period is not started counting. So that's the room of negotiation. That's when probably I can speak with an employer to say, hey, can I, be on the unpaid leave or be on the company's employees list so that I could maximize the grace period.
yes, that's wise approach to resolve this kind of issue. So I know not every employer is cooperative for this kind of issue, but at least you can request your employer explaining about your situation, being H1B employer, and then maybe you can request that is there any way you can be on the unpaid vacation, and maybe by doing so, you can try that your employer can defer the date of a termination, and that he can report to USCIS like later than expected.
Yeah, thank you for that clarification.
Of course. So here, because H1B is an employment-based non-immigrant status, as you know, it allows you your intent, the intent to work and the intent to reside in the United States. And thanks to your intent, H1B is a great transition for non-immigrants to apply for a green card without jeopardizing your non-immigrant status. And I'm sure some of you guys may have applied for a green card. Then what happened if H1B is terminated while your green card is in processing? If you apply for the green card while residing in the United States, mainly green card processing has a three-step. First, perm process. It requires obtaining a prevailing wage determination and file the labor certification with the Department of Labor. Second, I-140 stage. The form I-140 named Immigration Petition for Alien Workers should be prepared by your sponsor and should be filed with USCIS. And third, I-485 stage. The form I-485 adjustment of status should be prepared by you, and once I-485 is approved, you will get your green card. If you're on PERM or I-140 stages, maintaining valid status is very necessary, meaning that if you, an H1B employee, were laid off, it is necessary for you to transfer H1B or make the change of status timely so that you maintain your non-immigrant status validly. However, if you are in the stage of I-485, meaning that you are waiting for the green card after you file I-485, then you can continue your green card processing even if you're laid off from your H1B employer. Because by filing I-485, you are in the adjustment of status, a process allowing you from non-immigrant to a lawful permanent resident. And while being in this adjustment of status, maintaining your non-immigrant status is not necessary. So you can even work once your work permit is approved, which was applied when filing I-485, and there is no need to maintain your status separately. But this situation is quite applicable if your qualification for the permanent residence is strong and you do not have much concerns for obtaining a green card. So if your green card case is denied and if you did not maintain your status, you need to return to your home country upon denial of your green card case. So if you want to approach this issue conservatively, especially if you have any concern in terms of your permanent resident qualification, it is safe to maintain your non-immigrant status after being laid off from an H1B employer.
All right, sounds great. And I do want to add a note that for everybody asking questions, we really welcome you to ask your questions for now, to send it in the Q&A section. And our colleague is going to collect every question so we can have half an hour answering all of your questions. So all the questions are great. We're just going to answer them at the, at the other half of our webinar.
So yes, then what is the practical option for you after experiencing H1B layoff? First, you may consider H1B transfer. If you can secure your new job offer from a new employer during the grace period, which is 60 days, you may proceed to H1B transfer. This is definitely a good option to utilize the benefit of H1B status. And H1B transfer is a similar process compared to your application for an initial H1B status. So once your new employer offers your job and you accept it, your new employer needs to get a labor condition application named LCA from the Department of Labor, and it required to file Form I-129, the form that you use for your initial application for H-1B, and this should happen before your grace period ends. So in other words, if you can find a new employer and can file I-129 during your grace period, then there's no issue to transfer your H-1B.
Questions. So if I do find a new employer, if I get laid off from H1B and I wanted to do this H1B transfer, does it happen instantly, or is it gonna take my grace period? Is it gonna take certain times of my grace period, or is the transfer instant?
Oh, as long as you can file the Form I-129 within 60 days, like the last day of a grace period, then that should be fine.
So technically, somebody could still transfer their H1B at the last day of their grace period. We
Oh,
wouldn't
yeah.
recommend, but
Yeah, in purpose, they can do that, or mostly people are spending their time grace period to search a new employer. So they spend like 1 month or sometimes 1 or 2 weeks. Luckily, they find a new employer and then fire 129 as soon as possible.
thanks for your clarification.
Of course. So next page. Thank you, Ryan. But yeah, however, it is not always easy to find a new employer, especially with only 60 days limited time. Securing a new job and employer sponsorship can be very challenging, particularly in uncertain economic times like nowadays. So if your plan for H-1B transfer did not work out, alternatively, you may consider a change of status to other non-immigrant status. Change of status is an option for non-immigrant to change your status while residing in the United States. I have reviewed and handled change of cases at GoElite, and I see a number of non-immigrants are in need of legal support to do the change of status successfully. And next page, please. Thank you. And according to USCIS, USCIS state that if you want to change the purpose of your visit while in the United States, you must file a request with USCIS on the appropriate form before your authorized stay expires. Here, the appropriate form is Form I-539. To request a change of status, you must maintain your non-immigrant status validly when you file I-539 with USCIS. And USCIS explains that if you'd like to change your non-immigrant status to A, A3, B1, B2, dependent of E, F1, H4, J1, L2, M1, O3, P4, R2, dependent of TN, you must use the form I-539. Technically, if you want to have F1, J1, M1, and dependent status of most type of visa, you may need to do a change of status by filing I-539. And to give you a tip here, if you like to change your status to E2, H1B, L1, O1, O2, P1, R1, TN1, and TN2, the form I-539 is not applicable here, so be careful if you are considering start filing for H1B, O1, O2, E2, which are popular amongst non-immigrants. And the filing fee of Form I-539 is $370. And you can file I-539 promptly by sending mail, or you may do so online after creating your account on USCI website.
Okay.
And good news about change of status is that since June 2023, premium processing is available, especially if you're seek a change of status to F1, F2, M1, M2, J1, or J2. So without premium processing, it takes several months to get USCIS response. But with the premium processing, you'll be able to hear USCIS decision about in 2 weeks. And you can file Form I-907 with I-539, or even you can do so if your case is pending, like your I-539 is pending. And filing fee of I-907 for change of status to F1, F2, M1, M2, J1, J2 is $1,750. And while supporting many clients, I actually noticed that F1 and B2 status are popular when they consider change of status. For these two status, briefly, I'd like to go over what you need and the benefits and the disadvantage of each status. To change your status to F1, you definitely need to obtain a new I-20, which require you go through the process of obtaining an official acceptance letter from the school. And you need to prove your financial ability to support yourself. And here it is important to prove that you have funds for required tuition and your living expenses. You also need to show that your residence information that you're able to attend the school in the United States. And at the same time, you need to prove that you have a ties in your home country by providing your foreign residence information. And for B2 status, again, you also need to show funds to support yourself. And here, your funds need to cover the cost of your travel, leisure activity, and living expenses based on your plan. For B2, just like F1, it is important thing is that you need to emphasize that you have a strong ties in your home country and have an intention to return to your home country. And the benefit of F1 status is that you shall earn your academic degree, which is a part of your personal development. And you may utilize curricular practical training CPT or optional practical training OPT opportunity that extend your career path. But to maintain F1 status, you have to pay tuition and make a good effort to maintain academic good standing diligently. So being diligent to meet required activity of F1 status could be inferred as a disadvantage of F1 status. On the other hand, for B2 status, you don't need to pay tuition and you can secure your status in the United States without performing a specific required activity. So these are the benefits of B2, I can say. However, the duration you may stay in the United States with B2 is quite short and temporary, and you do not have any opportunity to gain your work experience or earning academic degree. And yeah, after seeing many change of status cases, I see many non-immigrants choosing F1 status eventually. And to summarize some aspect of F1 status, first, F1 status is quickly obtainable relatively because for many cases, you may have more opportunities to find proper educational institute rather than finding a new employer. And second, USCIS also understand non-immigrants' desire to pursue the education in the United States. And third, especially I-907 premium processing is available for change of status since last year. So you'll be able to get the approval quickly for changing status to F1. Of course, finding a proper academic program and proving financial ability for your tuition and living expense are required. It's a tough step. But once you obtain your F1 status, duration of your stay is not completely set, but can be continued as long as you attend the school validly. And if CPT, OPT is granted, the student can continue his or her work under authorized CPT and OPT program. In case you decide to change your status to F1 after being laid off as an H1B employee, you and your spouse can also change his or her status from H4 to F2. F2 status means that F1 visa holders are dependent status. With F2 status, you are not allowed to work in the United States, but you may study part-time. In case your spouse also wants to pursue a CPT program in order to gain work experience while studying, the spouse also can change his or her status from H4 to F1. So this is everything for today's presentation. I hope this was helpful for you. And yes, I'd like to hear from you if you have any question.
All right. Thank you so much, Joyce. I think we learned a lot in terms of, how change status work and how people can navigate through this tough situation. And
Thank
we
you.
did collect people's questions in the background. So let's just go ahead and jump into our question session. So the first question would be, I dropped out of my day one CPT program, after I get selected in my H1B, and when my H1B got effective, and then if I choose to change the status from H1B to B visa when I need it, and when I needed to change it back to H1B, I think, will it consider as a red flag for future H1B stamping or green card application? So this person was in F1 and then changed to H1B, then he or she wanted to change to B visa.
Oh, so she's quite like concerning that change her status often or to different kind of category would make a disadvantage for her future H1B or green card, right?
Yeah. Yes.
The answer is no. Of course, every decision by USCI is like their discretion, so I can't guarantee the outcome here, but merely changing your status to different non-immigrant status doesn't really mean that it could be a penalty of your future green card processing or changing to a new status.
Mhm.
You just need to explain the reasonable situation and in fact why you have to change your status to certain thing.
Yes. And let's jump into the next question. If I failed to do change status when my H1B grace period is over, how long can I stay in the US before I have to leave?
So technically, you need to leave this country as soon as possible because once you reach like 180 days as being an overstay, and then like before 1 year, then you'll be a subject of the bar of admission in 3 years, I believe, when you come back to United States. And then if your out of state date is longer, then the time that you have to wait to get the visa in the future is getting longer. So proportionally, it's getting longer based on your overstay situation. So yeah, if your grace period is over and if you have to leave, I recommend to do it as soon as possible before you reach 180 days.
Yeah, and just out of my concern, what is this person's options if in
That's a good
truth
question.
like this person's H1B's grace period is over, what can he or she do and
I do
if
see similar,
you wanted to
yeah,
stay.
cases. Uh-huh. And the student, the person who had the H1B and then she was laid off and then she couldn't find a new H1B transfer. So after thinking many scenario, she decided to go to school and she was looking for education opportunity and then she got the I-20 eventually. But she got the I-20 on her 55 grace period date. So it's like a last minute, she was able to get the I-20. So she was rushing to pack everything and then submit the document properly before reaching her 60 days of a grace period. But unfortunately, because of the weather, like circumstances, the California got a storm and then her package sent by UPS was getting delayed. So her package was received at USCIS a week after her grace period ended. So she thought that it would be a very problem for her, but thankfully USCIS sent an RFE request for further evidence and then asking her why you're late to submit your package. And then they were asking whether you have a reasonable explanation for such delay. And she was able to explain that her I-20 was quite like some issue late, and then she had a weather issue. Even she submit her package before grace period ends. So thankfully, her case was approved.
Oh, wow, it's approved. Then I would assume that it doesn't really work for any scenario. We couldn't guarantee, but if
Right.
this person, for example, I'm about to, you know, finish all of my grace period, or I'm 1 day, 2 days into my grace
Uh-huh.
period, maybe I could still start changing status in here in the United States and hoping that I got an RFE and I can explain a proper reason. For example, missed
Right.
delivery, other reasons, so that I have a proper reason that my
Mhm.
application was late, but I could still get approved if I'm just just 1 week shorter than that, into my grace
Right. I think that USCIS understood her situation and it understood her effort to change her status and pursuing her education in the United States. So yeah, it shouldn't really happening often. I don't say that you should rely on this kind of case, but I just wanted to introduce case to give you the positive thought and the
Yes,
process
we
about
don't
it.
we don't recommend you
Of
stay
course.
getting into your last minutes and do your change status, but you know
Mhm.
but this is what actually happened. So I'm glad that it happened. Already applied for B2, I assume change status, but it is still pending. Does it take longer to do a normal H1B transfer? Oh, what if I'm already changed to B2? I think this person wanted to do change their status from H1B to B2 and use B2 pending as like a period of time to find a job. And then what if he or she actually changed to B2? I think that's the person's concern.
Oh, yeah, just to make sure to clarify that I understood this question correctly. So, first, she wants to figure out the timeline for changing to B2
Mhm.
versus timeline to H1B transfer.
Yes.
Right. Oh, it's really based on the location that your file was submitted, and then like USCI has different method to process each cases. So I cannot really tell that which month is taking for B2 and H1B, but in general, I can tell that regardless of the status type of a non-immigrant status, mostly takes several months if you change to B2 or if you change to H1B. So that's why the premium processing is quite popular amongst non-immigrant because we have option to do it within 2 weeks. But yeah, to answer this question, there's not so much different. Yeah.
Yes, and I do want to put some example into perspective, is that I have seen people
Mhm.
to change status from for example, from H1B to B because they wanted to use that B pending, and then they got approved within, for example, like a month or like 40 days, because we will usually expect they to be approved like more than 3 months. Somebody takes like 6 months, so that you
Mhm.
will have that window to find your new job, like in that half-year window. But then all of a sudden you get approved within that 30 days, 40 days, and you wouldn't be able to change your H1B back once you get that H1B job. I wouldn't recommend people honestly to go to that be pending situation, because you can never expect. Some people would take half year, some people would take 30 days. And you have to guarantee that you can find a job within that short amount of time.
Right.
So we would recommend you changing to F1 status, because that you could still work. Once you find a job, you could still work under F1 status. So that's the difference. But it is your decision. I'm just throwing out the example in here, and let's move to the next question. May
Yeah,
I
it was
file?
very good advice though. Yeah, I like that. Thanks.
Yes, thank you. Next question. May I file both I-539, to change the status to B visa, and then also family-based I-485 within, the grace period?
Yes, correct. So you shall file I-539 to maintain your non-immigrant status. And since you mentioned family-based I-485, I think that you have a connection. You can file the green card based on family-based, especially meaning that you have to file I-130. So once you submit I-539, that means that you're going to keep your non-immigrant status validly. At the same time, you can file I-130 for family-based green card, and concurrently, you can file I-485 as well.
Okay, thanks for the clarification. Next question. Which day will USCIS consider as the start date? I think we kind of briefly mentioned that in the earlier presentation, but will it also be the last working day or the day receiving the last paycheck? How would that, count?
So yeah, I know it's quite tricky issue, and I think that Ryan and I was talk about it when we were approaching about the unpaid vacation thing, right? So here I would say that the answer would be the day receiving the last paycheck. That would be the safe way to think. That is like once you got the last paycheck, after that, if you stop working, if you don't get the paycheck, then your grace period start to run.
Okay.
Mhm.
Next question. Can I file I-539 by myself, or has it to be done through an attorney like through you?
Yes, you can do file I-539 by yourself. Like USCIS allow you to do it online, but we see many cases like getting RFE, meaning that request for further evidence, especially if you have a long history in the United States, or if you have a very unsmooth transition between non-immigrant status. If you have the kind of record, if you have any like similar thing or unwelcome history, if you have any, then RFE is really, yeah, it's like something that you can expect. So I would just recommend that think about your history and then collect the evidence if you can do by yourself. But if you need support, like legal support or consultation, maybe advise you to seek the immigration attorney.
Yeah, absolutely. You put that very well. I think for our webinar, we are trying to educate people. Like,
Mhm.
we are throwing out your options. So you can definitely file your I-539 by yourself if you are confident with your evidence and
Yes.
if you don't really have a complicated background. So if you need any assistance, you can also consider, getting help from somebody like Joyce, who is experienced in the change of status field. It's really up to you. And I think we are here to, guide you through the process, whatever is necessary for you. And let's go into the next question. Can you share examples of home ties evidence for F1 renewal, on the second master program in the US? I think this is not really that direct to change the status, but also can you just share a little bit on that?
Sure. Sure, I wanted to answer this question because this is quite a common question as part of RFE, like further requests of evidence, if you're especially changing your status to F1. So we have to prove that you have a strong ties in your home country by providing foreign residence information. It could be including like home ownership maintained by your parents, or the parent's affidavit or statement stating that this child used to be living with me, and then she has the intention to live with me once she complete her education in a state. And the utility bill of your parents' house, if like you keep the same residence there, then adding the utility bills for recent month, that would be a good evidence to prove your foreign residence.
Okay. Thank you for that. Next question. Any legal concerns of going from H1 to B1 and back to H1 later? To change from H1B to B visa during the grace period, can I also apply for can I apply on day 1 and indicate a start date on day 61? I think a very complicated situation, but hopefully Joyce can answer that.
Yeah, so to clarify this question, so she has concern changing her status from H1B to B1 and then back to H1, right? And
Yes.
yes, so I think I did answer for a similar question, but there's no concern. Yeah, as long as you is able to get the new employer to file the petition for H1B, then there's no problem to back to H1B status later. And to change from H1B to B visa during the grace period, can I apply on day 1, indicate the start date on day 61, the future date? Yes. I recommend that put the starting date of new status within the grace period if possible. But if have to extend your grace period as much as you can, then putting your starting date as a 61 is still okay. But I still recommend you to put in within the 60 days.
All right. Thank you so much, Joyce. Let's go to the next question. Is it risky to change from H1B to B2 with I-140 approved?
Oh, technically the answer is no. If you got approval of I-140 that was prepared and sponsored by your H1B employer, then like changing your status from H1B to B2, even you got approval of I-140, looks weird. But it doesn't mean that would be a problem. If you got the green card interview later, if we're asked about this situation, you just need to provide a reasonable answer that why you have to change your status to B2. And if you got the approval of I-140 from different sponsor, who is not your H1B employer, then changing your status to H1B to B2 doesn't really make any difficulties to process green card.
Okay. And I think, to add on one more thing to that is that we wouldn't say it's risky, but then also you need to find a solid reason why you want to, when you get the RFE, for example, if we're only hoping, for the best, but why are you changing to B2? I think that would be toughest question some people have to answer. And we do recommend you to work with the lawyer on this instead of just, writing your own reply letter on this, because that's why, when people are messed up in this situation. But then if you do want to consider to change to F1, I think there are solid reasons here, because once you worked in the US as an H1B worker, you have every right to go back to school and, to have additional skills and knowledge to go for a higher career path. So just to put, your options out there. Next question, if I change to a B visa and if it is still pending, will I find a new job? When I find a new job and transfer my H1B, should I leave the US and re-enter to activate my H1B?
Oh no. So I see these kind of cases. You already submit the COS change to B status and it is pending. And now you find new job, you can transfer to H1B. So here, you can try to put the COS to H1B, but we can't really guarantee which one will be approved first. So if you're lucky enough, then your COS application to new H1B can be approved earlier than your COS to B. Then you can continue your status as being a H1B. But again, COS to B status is approved first, then H1B, then it's quite like complicated because from B status to H1B status, you cannot use change of status. It was part of my presentation earlier. To change your status to H1B, I-1 to 9 form is required, not the COS form. So the way you change the status to B2 or H1B is quite different. So it's really timeline, which one is approved first.
Thank you. That was well put. And let's go to the next question. Currently, I'm on H4 visa. For changing to F1 visa, how many days will it take for a regular and regular change status and premium process? And once I receive F1 visa, can I work on day one CPT?
So regular I-539, I would say in general, it takes up to 6 months. Earlier, you can get a response like after 3 months, but it could take up to 6 months. But with the premium processing, you get the response in 2 weeks, like 14 business days. So they might approve your case directly right away, or if they need more evidence, they will send you RFE immediately. But definitely, it will save your time. And once you receive F1 visa, can I work on day one CPT? Yes, as long as you just find the authorized CPT program and then the school is communicating with your employer, then definitely you can start right away.
Yeah, absolutely. I think before you do apply for day one CPT, I recommend you to talk, to one of our consultants, or, you can scan the QR code to talk to us so we could find you the best program that fits your scenarios as an H4 and then change the status, because different universities do have different requirements, and some universities don't take change of status students, or if they take it, they will let you wait for a half a year before you can start day one CPT. So do consult with us before choosing your program. And the next question, if I apply for EB2 NIW, and does its acceptance or rejection have any effect on my H1B status?
The answer is no. So even if you will get the process of green card and then you got like approval or denier, approval of course is good news, but if you get rejection from the USCIS, your green card process is rejected, but doesn't really make any impact to your maintaining non-immigrant status. So maintaining your H1B status doesn't really get impacted anything.
Okay. Next question, to change from H1B to B visa during the grace period, can I apply? I think we talked about this, right? Can I apply?
Yes,
And the
right.
answer is
Good
yes.
question.
We wouldn't recommend you to do that on day 61 because it have its risk.
Correct.
Okay, let's go to the next question. My grace period is 60 days, will end in middle of February. Which status do you recommend me to change to? Is it B visa or is it F visa? When do you recommend me to apply to change status?
So yes, I don't see your entire situation circumstances, so I can't really give you the legal advice at the moment. But as we go over the benefit and disadvantage of a B2 and then F1 status, I'm sure both are applicable for you. But if you are seeking the longer duration of stay here, and if you are seeking for a chance to get the working experience, then F1 would be beneficial for you. And yeah, to apply the change of status, of course, you have 60 days to file your I-539 within 6 days, then that's fine. But I recommend to do as soon as possible. Immigration matter always timely and always be diligent. So I want you to do it as soon as possible. And then I think that for this question, our consultation team in GoElite will be helping you for many aspects. So yeah, if you have any question, contact your GoElite consultation team.
Yes, I would because time is ticking. If your grace period is ending on February, middle of February, you still have a little bit more than a month. So I think
Right.
whichever visa types that you prefer, you want to
Mhm.
change to, I think you should start soon because that
Yeah.
will you will be more prepared on that. And if you do want to,
Mhm.
talk about your personal situation a little bit more with Joyce, you can also, through us, you can book a consultation session with Joyce, so you two can kind of discuss that into a further step. And we have the next question, if application from H1 to B is still pending, even if I'm out of my H1B grace period, out of the 60 days grace period, can I still stay in the US legally?
The answer is correct. Yeah, once you file Form I-539 properly, timely to USCIS, then while you're waiting for the answer from USCIS, you can stay here in the United States legally. So I recommend you wait for longer. Um, in case if you get the rejection of the case, then you have to leave this country. But before you got the denial of cases, usually if USCI has a negative impact about your case, that means that they will send you something, which is RFE. So I think that your case is not directly denied, but you'll have a chance to talk to USCIS by submitting further evidence. So I hope that you got the good news soon.
Yes. I do have one question. If,
Sure.
for example, somebody's in their H1B and they wanted to change to B visa, and once, their H1B expired and then their change, for some reason, their change of status applications got denied, can this person still do transfer H1B if the person's initial change of status, application was denied?
So just to clarify the question, the initial status was H1B, and then
Yes,
tried to
they
change
wanted to
to
change to B visa and get
B visa.
rejected,
Uh-huh.
and he still filed for a H1B transfer.
So in here, does the person has a grace period or
No, like for example, for this scenario, this person's H1B grace period is ending, and
ended?
maybe he or she is hoping to do a H1B transfer while they are waiting for that be pending, but then the change status got declined. So I will assume that you wouldn't be able to change your H1B to transfer your H1B visa because your H1B visa is no longer effective.
Right, especially the grace periods end, and then if the status of H1B is terminated, then and then COS was rejected, then the person doesn't have a standing good status, valid status to apply for different thing.
Okay, but that doesn't really happen often. At least some people will get an RFE or an NOID first before that, right?
In fact, I see that I don't want to make a generalization based on my experiences, but I see that if people are making a change of status in the United States while residing in here and then
Mhm.
changing their status to different non-immigrant status, USCIS is willing to listen from you, like collecting more evidence and before they really make a decision for denier. So this story is quite like especially when we compare your experience that you are doing the interview at the U.S. Embassy in your home country, the rejection rate of a visa at the U.S. Embassy versus the COS change of status cases in the United States, then I'll say USCIS more generous about the COS attempt in the United States.
Mhm.
So if you have a desire to pursue certain non-immigrant status, and I know it's quite hard to handle them, but if you want to pursue something here, then try to with the COS and then see how USCIS will respond to you, how they react to you. And if they give you, provide you a chance to provide a further evidence, then diligently responded, timely, perfectly, and you can see the better result than just going back to country and then getting the interview at the U.S. Embassy.
Absolutely. I think this is our last questions in here. So I want to thank everybody for coming in and attend our webinar session. And I want to thank Joyce for providing your very helpful insights in terms of, how people are dealing with H1B layoffs and then how do you do change status applications. Thank you so much, Joyce.
Thank you.
Yes, and for everybody that if you have a further, follow-up questions after this event, we will gonna post, the recordings on our English YouTube channel. So we will send you guys an email on the recording. And if you have, personal questions, you can also scan the QR code or find the links in this meeting's chat bot so you can book a consultation with us and hopefully we can solve your questions. And this is it for today's webinar. I want to thank everybody for coming. Thank you, Joyce. And we are looking forward to see you guys next time.
Thank
Thank
you for
you.
having
Thank
me
you,
today.
Joyce. Thanks, everybody. Bye-bye.